Thank you, everyone. Thanks for inviting me here today. It's a pleasure to spend some time with you. As I was introduced, I'm Judge James Michael McGing, and I'll tell you a little bit about my background because I think that's important for everyone to hear. I grew up in the city of Chicago, and originally by what's known as North Avenue and Cicero. Spent most of my childhood around the Belmont, Austin area. I don't know if you're familiar with that area at all, but I went to DePaul University and DePaul University School of Law, and very good, Blue Demons. And I worked as an assistant state's attorney, and then I worked as a criminal defense lawyer. And I think that's important because it makes you more well-rounded about the criminal justice system itself. It's one thing when you've been a prosecutor, but when you've also done criminal defense work, you see it from a completely different spectrum. And the clients that you deal with, it becomes personal. I don't care if you're trying to keep it impersonal. It's very personal. You know, you learn a lot about the people that you're representing, about their families, about the way they've grown up and the way they've been treated by people and how they got to where they're at. And during the course of that, during the course of my law school days, I actually worked in the Criminal Appeals Division of the State Attorney's Office writing appellate briefs. So I started getting a lot of experience there doing that. And I also wrote briefs for outside agencies and for outside attorneys. And even when I was in private practice then, I did it for Illinois prosecutors' offices outside of Cook County where they don't have their own office. And it really gave me a great perspective on doing research and writing, and I found that I really enjoyed it. I enjoyed doing the research. I enjoyed writing briefs for the appellate court, and I continued to do that when I was in private practice. And that's really what you're doing as an appellate court justice is doing research and then drafting opinions. I had my own litigation firm with two other people. I was a partner there for 14 years. We did civil litigation, and during the course of that, I was appointed as a special state's attorney to represent Cook County in a number of cases, and I ended up becoming acquainted with the then sheriff, Mike Sheehan. I actually was representing the office before he became the sheriff. And during the course of that, he offered me a position. And at first I said, you know, I'm really not interested. I have my own law practice. But he was persistent, and there was a reason why. I ended up working for him, and I have to tell you, I really enjoyed it because I felt like I was part of a lot of changes and accomplishments in that office. I was able to work on projects, things that I really wanted to do. I chaired the 911 program, which brought 911 to all the unincorporated areas of Cook County, and there were 7 communities at the time that didn't have 911 service back in the 90s, which seems, you know, very strange to all of us today. But it didn't exist back then. And then I served on the 911 board for a number of years. I also chaired what's known as the LiveScan project. We called it CAB's Criminal Apprehension and Booking System. Prior to that system being implicated in Cook County, and I was able to go to Washington and get money from Springfield and some money from Cook County, and then from all of the municipalities that were involved. Over 100 suburban municipalities signed up to be part of that program. What was happening is when somebody was arrested, they would be taken to a police station and they'd be fingerprinted. And those are the old ink and roll things that we used to see in movies. But unbeknownst to everyone, what happened with those fingerprints was they were taken and faxed to Joliet, to the Bureau of Identification, to the state police. And oftentimes people shared the same name. And the warrant system was in a terrible state in Cook County. If your name was John Smith, you could be darn sure there was probably a warrant out someplace for someone named John Smith. And there were no identifiers that were listed. And what this system did was enable people to be identified very quickly. It takes just a matter of minutes now for the fingerprints to be electronically collected and sent to the Bureau of Identification in Springfield and come back. So you know if it's the person you're looking for or not the person you're looking for. And then on the other side of that, it stopped people from using aliases to say they were someone else when they were arrested, let's say, for a misdemeanor. And there were all these stories back then in the 90s about somebody who might have been wanted for a serious sexual assault in another state, but they were arrested here for a misdemeanor. By the time those fingerprints came back on a misdemeanor, and it would be embarrassing for law enforcement to tell you this, but they were actually sent back in the U.S. mail. So they were faxed down there for a misdemeanor. They'd be sent back in the U.S. mail. Of course, they came back sometimes 2 weeks later, was pretty much the norm on misdemeanor arrests. Well, that person's long gone. So it could be a serious felon that everyone was looking for, and they know, of course, that they're wanted, so they would use an alias. So it really kind of bridged this system, and it's something that I'm really proud of that's in use today all throughout Cook County. Some of the other things I got to work on while I was there is alternative sentencing programs, which was something that I became really interested in. You know, I went and worked on the alternative programs at Cook County Jail, and the reason for it is because there's so many nonviolent people that are sitting in the jail, and oftentimes there really isn't a reason for it. And I have to say that the Sheriff, Mike Sheen, was real supportive of us doing this, creating a boot camp. And I wrote the original legislation. It was called the Cook County Impact Incarceration Program. And, you know, we looked at programs all over the United States, and people would talk about Rikers Island in New York. Well, it really was just a military program. There was no follow-up. There wasn't the job training. There wasn't the drug testing. There wasn't the educational aspects after you did all of this, you know, the military-style indoctrination. What we decided to do was do something different. It's more military leadership principles about empowering people. And a lot of these young men that were in the program really just needed a little direction. And it has one of the lowest recidivism rates in the United States. People come from all over the United States to see the Cook County Boot Camp. And it's been really successful. I'm really proud that I wrote that legislation that became the law that created the program. And it wasn't easy, because back then in the 90s when I was doing that, you know, there was a different prosecutor at the time, and he didn't want the program to be an alternative to prison, which is what we wanted it to be. Instead of sending guys off to prison for several years, you know, give them another chance at something. These are nonviolent offenders. He wanted it to be a more severe probation. Instead of people just being sentenced to probation by the court, they'd have to go to the boot camp. So we went out in the end, and he ended up acquiescing to us and agreeing. So those are some of the things I worked on, including the Women's Justice Advisory Council for Cook County, which created a lot of programs at the jail that are just phenomenal. The Moms Program to get you know, women parenting skills, and women who are pregnant, get them out of the jail and have them in a facility that's not Cook County Jail, because it's obviously not healthy for anyone, for the mom or for the you know, the whole birthing process. And then there were even some home economic classes and day drug school, so that they could go home at night and be with their family and with their kids, and then, you know, come during the day for the training and the education and the counseling that they needed. So I'm really proud of those things that I got to work on while I was there. I also was chosen while I was there to attend the FBI National Academy in Quantico, Virginia. I went to the FBI Academy. I graduated from there in 1999. I stayed involved with that board here in Chicago. There's a Northern Illinois branch. I was the president of it. I served on that board for 6 years. I also was appointed at the time by Janet Reno to the Anti-Violence Initiative in Chicago to come up with programs to try and abate violence within the city of Chicago. I was appointed in 2003 to the Department of Justice Oversight Board of the Regional Computer Forensic Lab. That's a lot, but basically it's the electronic branch of the federal government, and there are local law enforcement assigned there. They work on all the cases that you'll see with child pornography or public corruption. You know, when you see these people go in and they're mirroring the computer systems at, you know, an office or something, that's all done by the RCFL, the Regional Computer Forensic Lab. And they had a board that oversaw what those people were doing, and we would actually interview any of the intelligence analysts that got hired there, and they would go through security checks. They had to actually obtain top secret security clearance to even work in there, because there were national security cases. But those are the kind of things that I was able to do, and I'm very proud of that. I've been a judge for 5 years. I sit in the only courtroom in Cook County that's a public nuisance courtroom. It's a program that Judge Evans has been really supportive of, our chief judge. And he asked me several years ago if I would be interested in doing that courtroom, and I've been in there for 2.5 years. It's really unique. Basically, the city of Chicago files civil cases against property owners, or sometimes it's tenants. It can be bars or commercial establishments, and trying to abate criminal activity. It's trying to make somebody be responsible for their property to abate the criminal activity that's taking place there. It oftentimes is drug sales. It can be, you know, illegal gun sales, and so forth. But I've had buildings where, you know, a gang's taken over an entire condominium building, and the owners can't even get into their own building, you know, and so they're looking for help too. It's not necessarily that the owner has done something wrong. Oftentimes, I call it the innocent owner. It's the owner who just needs some help from somebody. I had a situation even where a large apartment building, and the owner had spent, on the south side of Chicago, had spent a ton of money trying to fix it up, and he was standing in front of me, you know, visibly upset that he had tried to get help and nobody was helping him. But because the city of Chicago was a party in that case, you know, I was able to order them to do things with the Chicago Police Department to basically take back his building. Otherwise, they were telling him, you have to go through eviction court. He said, eviction court? These people took over my building, locked me out. They have dogs in there. They're selling drugs in this place. There had been search warrants executed there. Those are the extreme types of cases, but it's really an enjoyable place for me as a lawyer. As a judge, I get a lot of motions. I get to do a lot of research. I get to do a lot of written opinions in there, and I think that's some of the things that have benefited me to prepare me for the appellate court, which I'm running for. There are 18 elected spots on the Illinois Appellate Court, 1st District, which is Cook County. There are 24 justices there, but 6 are appointed or assigned by the Supreme Court, and 18 are elected. 6 of those 18 are up this time. It's really unheard of. And the only reason the spot is open that I'm running for, Justice Cahill's, is unfortunately he passed away in December, so it was a last edition. It is in alphabetical order, so Cahill being the first race. It's the first race after the Illinois Supreme Court, and I'm number 115 on the ballot. I have been found qualified or recommended by every bar association, and I've been found highly qualified by the Chicago Bar Association for the Illinois Appellate Court. I serve as the chairman of the First Municipal Committee for the Chicago Bar Association. We have monthly speakers. I contact them and ask people to come in. We've been fortunate of the caliber of people that we have that come and talk to us. I think it's important to have people from all varieties. I've had everyone from Patrick Collins, former assistant U.S. attorney, to Sam Adams Jr. came after the Blagojevich trial to talk to us about what it was like doing that case, the highs and lows of it, and how he prepared and how he went about the defense with him and his father defending him. So it's pretty fascinating things. And next month at our March meeting, I actually have Judge Zagel is coming to speak at our group. I know it's going to be packed. And it'll be really enjoyable because he's going to answer questions after, a half-hour, 45-minute presentation. So some of the things I would like to see on the appellate court that aren't really done today is I think that all of their decisions should be published. They're not all published. If you're familiar with the process, there's something called a Rule 23, which is a Supreme Court rule. So I don't have the ability to change it even if I was on the appellate court, but I certainly would be asking the Supreme Court reconsider it. I think it's important. Rule 23s are cases where they say, well, it's not precedent. Maybe you refer to it as a run-of-the-mill case, but no case is really run-of-the-mill. And I think they all should be published because it stifles evolution of the law. Maybe the law is pretty well settled in that case, but the facts could be unique, and then maybe somebody else would say, those facts are analogous to my situation, or a lawyer could help advise a client before they even get to court and say, this Rule 23 came out that we can't cite as precedent, but it's authoritative law. And so I would like to see that. I would like to see more oral arguments at the appellate court. I think that's when everyone really gets prepared, including the justices, for their cases, because they have to have read all the briefs. They have to ask pertinent questions of the lawyers who are arguing before them. The one thing that I've committed to, with the bar associations, with everyone who asks me, is that I'm going to be diligent. They've said in the past that I'm fair and impartial and I'm diligent about my work. That's what I'm going to carry over to the appellate court. I'm going to make sure that my opinions are done in a timely manner, that people aren't waiting for them, because I think that's really unfair to litigants, especially on the criminal side, when people might be waiting, they're already in prison because they've been sentenced. They've had motions for retrial, perhaps, or for a new trial that have been denied, and now they're sitting in the Illinois Department of Corrections waiting for the appellate court to decide their case. They're oftentimes very prompt with their opinions at the appellate court, and oftentimes the cases are delayed because there's a timeliness issue with preparing the records, having them all transcribed. So I'd be an advocate for more court reporters in the system so that the transcripts could be prepared in a quicker manner, because it really is about somebody's life and they deserve that attention and that timeliness, I think, from the system. I think that's about it. I'm number 115 on the ballot, and I hope that you'll consider voting for me on March 20th, or early voting or mail-in voting, which is underway right now. And early voting starts, of course, Monday. Thank you.